All right, I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please call the roll?
Senator Harris, Senator Orenshaw, Senator Dondero Loop, Senator Wynn, Senator Hansen, Senator Krasner, Senator Stone, Chair Scheibel.
Here, thank you. Please mark Senator Harris present when she gets here. I know she's presenting in another committee. We will be going a little bit out of order this afternoon to accommodate the schedules of senators who have to present elsewhere. But I believe that we have Treasurer Conine with us in Grant Sawyer. Therefore, I will start with AB 55. So I guess we are going in order so far. And I will open up the hearing on AB 55. Please go ahead whenever you're ready.
Thank you very much. Good afternoon, Chair and committee members. For the record, I am Treasurer Zach Conine. It's my pleasure to be here today to present Assembly Bill 55. And there is a pretty lively crowd behind me, so I apologize if they violate the no applause rule. Broadly, Assembly Bill 55 makes various changes to Nevada's unclaimed property laws, which follow national best practices that will help to modernize and align our governing statutes here in Nevada. Pursuant to NRS 120A, the Treasurer's Office administers Nevada's unclaimed property program. In this role, the office takes custody of lost or abandoned property from individual or business holders and works to reunite it with its rightful owners. When property cannot be reunited with its owner, it's held in perpetuity by the state. When you have a moment, I would encourage everyone to search for themselves at website that I'll give you after questions so that people are paying attention, to see if the state is holding on to any money of yours. It takes less than a minute to search. For scope, last year our office processed and approved 37,290 claims, which resulted in a return of $42 million. On the holder side, last fiscal year, holders reported and remitted over $83 million in unclaimed property to our office. Since I took office, we have returned more than $200 million in unclaimed property, a record for any four-year period in state history. And Chair, unless there's any questions at this point, would love to walk through the bill.
Please go ahead.
Excellent. Sections 2 through 6, 14, and 15 of the bill make necessary cleanup changes, such as ensuring continuity in definitions and updating references to other sections that are being changed in the bill. Section 7 of the bill makes various changes to the section of our statutes that outlines what kind of property needs to be reported and when that reporting must happen. These changes are technical in nature and are designed to clarify many of the more nuanced questions that we see arise in our holder and audit working groups related to specific industries such as insurance, retirement, and pre-need funeral service contracts. Section 8 of the bill clarifies the presumed abandonment date for gift certificates and removes a piece of existing statute that makes the owner's last known address for gift certificates the state treasurer's office in Carson City. This has created a different standard among property types, and we'd like to ensure they're all properly aligned and reported in the same manner. Section 9 makes updates as to how and where a holder of unclaimed property should report to our office. Sections 10 and 11 replace requirements that our office purchase print ads. We found that earned media receives a much greater response than publishing ads in the newspaper. We've also adopted an active return model, seeking out Nevadans to return their unclaimed property. The updated language still requires the Treasurer's Office to provide notice in the form of a press release and through the publishing of a public notice, both of which we believe fulfill the spirit of the existing requirements without mandating the expenditure of advertising dollars. I would note, while this update does not mandate the purchase of any advertisements, it does allow the office the option, if we choose to, for example, targeted digital ads, geofenced ads at events such as career fairs, and etc. Section 12 allows the office to accept property prior to it being deemed abandoned by statute if the office believes it to be in the best interest of the state. This happens most often when a business dissolves, finds itself in a place where they're trying to make sure all the property can be turned over, but it hasn't yet reached the age where it would escheat naturally. Section 13 updates existing law to allow our office the opportunity to seek records from other state and local agencies that would otherwise be deemed confidential. For a bit of background, when the pandemic began, as many of you know, our office looked for ways we could assist Nevadans who were hardest hit and were struggling. We teamed up with Dieter to use the unemployment insurance claimant list to cross-reference our unclaimed property database to determine if we were holding any unclaimed property for UI claimants. Over the course of the initiative, we returned over $2.3 million in unclaimed property to UI claimants. However, our statute did not allow us to automatically send these individuals checks for their unclaimed property, despite our database matching on names, birth dates, social security numbers, and addresses. Rather, each claimant had to be sent a letter with instructions on how to claim their property. To remedy this, in 2021, our office ran Senate Bill 71, which was passed and signed. Senate Bill 71 allows the Treasurer's Office to initiate a claim on a property owner's behalf, allowing for even greater efficiencies when returning unclaimed property. When we began seeking out additional opportunities to expand these initiatives, we quickly ran into another issue. Much of the information held by state and local agencies are, rightfully so, deemed confidential. The section of the bill gives the Treasurer's Office the ability to receive these records despite their confidential nature to the public. For instance, imagine if we could automatically match individuals who held a teaching license in Nevada with their unclaimed property. Section 14.5 allows our office the ability to establish regulations to protect property owners in agreement for return of property. Section 16 repeals an existing section of NRS 120A that defers any question of law to the Uniform Unclaimed Property Act. We are seeking this repeal for two reasons. First, the Uniform Unclaimed Property Act, the specific uniform law which is cited, has since been updated and will likely be updated again in the future. Thus, the statutory reference is outdated. More importantly, there are sections of the uniform law, both the current and previous ones, that are incongruent with Nevada's legal framework and thus in conflict. That concludes our presentation. Very happy to answer any questions. Thank you all for the time and consideration of this bill.
Thank you so much. Are there questions from members of the committee? Senator Stone.
Thank you, Mr. Treasurer, for your presentation and making the process easier for people to identify whether they have any unclaimed property in the state system and making it easier for them to get that property removed. Is there any period of time that the state will have possession of these assets after which it reverts to the general fund, 20 years, 30 years, or is it just in that bank account forever until somebody claims it?
Treasurer Conine, for the record, thank you for the question. We hold that property in perpetuity. Of course, the longer that we're holding the property, the less chance there is of it being returned because perhaps the original claimant passes away and then we've got to get to a niece, a nephew, a child, a grandchild in order to give it back. But we do hold it in perpetuity.
Thank you.
Other questions? Senator Craster.
Thank you, Chair. Thank you for your presentation, Treasurer Conine. I was just looking at Section 10 that says that property presumed abandoned in the form of stocks, equity, retirement accounts, virtual currency, no longer needs to be published in the newspaper of general circulation previously, or current law says not less than 6 times a year. And I see that you're trying to just create a database. I mean, the database is good, but I'm wondering if you might accept an amendment to publish it in a newspaper of general circulation one time.
Treasurer Conine, for the record, and I'll certainly invite any members of the team up here for additional color if they've got it. But here's what we found. Publishing property lists in a newspaper is creating almost no additional claims, right? What we are able to do is go to the newspaper and say, hey, Elko Daily News or Nevada Appeal or wherever, if you can publish where the website is, if you can go here, we're able to get people to fill it out. We also have people who walk into the Treasury offices in Carson City and here at Grant Sawyer to fill out the property. But the information that shows up in the paper is so ineffective at actually returning property that it really just becomes a staff burden to place those ads as opposed to an actual way to return dollars. Also, just functionally, because the database includes thousands of potential pieces of property and people move, right? If we are listing, say, property that is supposed to be in Las Vegas, but that individual has moved to Gardnerville, they'll never see it in the paper that we're referring to. And so we want to focus our efforts on places where people are looking.
Follow-up, Chair, please. Well, I appreciate that you find it ineffective, but not everybody has access to the internet. Hard to believe. A lot of people in the rurals have a spotty connection or no internet access and no computer. And they do rely on the newspaper. And right now, if it says not less than 6 times, I'm only asking if you could do it just 1 time per year. And an FYI, I do read it when it comes out.
Treasurer Conine, for the record, happy to consider. Senator.
All right. Other questions? Senator Orenshaw.
Thank you, Chair, and thank you, Treasurer. And I guess my question, if I could indulge me with 2 questions, Chair. On Section 10, the part with the newspapers, you know, I represent an urban area, but a lot of my constituents who are seniors, you know, are still look to notices in the newspaper. And I just wonder, what is the expense right now in terms of publishing the list of unclaimed property? How much do you project will be saved? I think in the ideal world, I'd like to see both the website and the press releases and at least some publication still happen, just for people who do like to consult the newspaper. But I'm just wondering, what does that cost the Treasurer's office right now to publish that? What kind of savings are you looking at? And then I have one other question after that, unrelated to this section.
Treasurer Conine, for the record, we can follow up with the exact cost. It's in the thousands of dollars a year. It's one of the only uses of one of the marketing contracts that we have that we think we can reach more people through the press. And I think that's sort of evident by the success that we've had in increasing claimants. We have more than 40% more claimants for all of last year, this year to date, right, with a little bit farther to go. We've returned more unclaimed property than any office in history, and we're doing that through press, right? It's almost all earned media. And of course, by definition, when we use unclaimed property dollars to advertise, we're then taking away from the dollars that can go back to the general fund on an annual basis. But we can give you the exact number. It's in the thousands. It's not in the 20s of thousands.
Thank you, Mr. Treasurer. And then I guess my last question, if you'll indulge me, Chair, with one more question. The language in the repealed section, NRS 128.750, as to this chapter shall be applied and construed to effectuate its general purpose to make uniform the law with respect to subject matter of the Uniform Unclaimed Property Act among the states that enact it. If that's deleted, do you think there'll be any issue if let's say, someone has unclaimed property in multiple states in terms of trying to work across other states that have the Uniform Unclaimed Property Act, or do you... I guess that's my concern. If we're not going to look to the Uniform Act for guidance, and if there is someone with unclaimed property in multiple states that have adopted the act, do you think we'll run into any issues there, or do you not see that as a problem?
Treasurer Conine, for the record, I appreciate the question, and obviously we want to make it as easy as possible for both holders to report and turn over unclaimed property as well as claimants to get it. My understanding, and I'm looking over at my team who will nod their hands or not, depending on this answer, is that no state has fully adopted the Uniform Act. A couple have now. Okay, so a couple have now. 2 years ago, it was none. But most states have different unclaimed property laws, and so holders are working across the spectrum to make sure that they're getting them correct. And the changes, the moderate changes between our laws and the uniform laws are intended to kind of protect Nevadans, right? And so while I expect as the uniform law continues to progress, we'll continue to get more states on it, just as we have with uniform laws that have been around for longer. But RUPA is a little young, and so we're continually looking for ways to make sure it works for us. I'll see if my team has anything they want to add to that. Okay, no, thank you.
Okay, thank you, Mr. Treasurer. Thank you, Chair.
All right. Any other questions on AB 55? I don't see any. So thank you for answering our questions, and we'll move now to testimony in support of AB 55. Anybody wishing to give testimony in person is invited to do so now. And I don't see anybody coming to the table in Las Vegas or Carson City, so we'll go to the phones for testimony in support of AB 55.
Would like to testify in support of AB 55, please press star 9 to take your place in the queue. We have no cause to testify in support at this time.
All right, then we will move to testimony in opposition to AB 55. I don't see anybody coming up to give in-person testimony in Las Vegas or Carson City, so we'll go to the phones for testimony in opposition to AB 55.
If you would like to testify in opposition to AB 55, please press star 9 to take your place in the queue. We have no callers to testify in opposition.
All right, then we will take neutral testimony on AB 55. I don't see anybody coming forward to give in-person testimony, so we'll go to the phones for neutral testimony on AB 55.
If you would like to testify in neutral for AB 55, please press star 9 to take your place in the queue. We have no callers testifying in neutral at this time.
All right, then that brings us to the conclusion of testimony. If all of that raucous debate has led you to any final comments, clarifications you want to make, please go ahead.
Thank you, Chair. Treasurer Conine, for the record, I would just like to encourage everyone to check claimitnevada.org for your unclaimed property. Mother's Day is coming up. I hear it makes a wonderful Mother's Day gift. I don't hear that from my wife, but I've heard it from other people. So please, claimitnevada.org. Thanks so much for having us.
Thank you so much for joining us today in Senate Judiciary, and I will now close the hearing on AB 55 and open up the hearing on AB 356. You should all have both the reprint one of AB 356 as well as an amendment proposed by the Washoe County Sheriff and DA's offices available on Nellis. What we're going to do in this particular case is hear the presentation of the bill, AB 356 first, and then we'll hear a presentation from the sponsors of the amendment on their amendment. And you'll have a chance to ask questions on both after their respective presentations. Go ahead whenever you're ready.
Thank you so much. Good afternoon, Chair Scheibel and members of the committee. My name is Jill Dickman, and I represent Assembly District 31 in Washoe County. I appreciate the opportunity to come before you and present Assembly Bill 356. This bill would make it a crime to place a mobile tracking device on someone's vehicle without their consent. To provide a bit of background on why I came to request this bill, as many of you may know, recently a number of elected officials have been the victims of a serious invasion of privacy, having been the targets of unwarranted GPS tracker placement. They've had devices placed on their vehicles and the vehicles of some of their family members. In a time where threats and harassment of public officials and their families has become more common, the placement of these mobile tracking devices is a violation of privacy and brings distress, fear, and potential danger to a victim. Although this issue has made the headlines recently, it can impact anyone. Stalking-related incidents due to technology are on the rise. It's estimated that 14% of stalking victims were tracked with an electronic device. When I learned of these incidents happening in Nevada, I was frankly appalled to learn that this is not a crime. And I also had a number of people contact me who were as incredulous as I was. And after a bit of research, I learned this type of tracking is only legal because nothing in our statute specifically prohibits it. In this day of advancing technology and the low cost of new technologies, the use of these devices is becoming more and more prevalent, and this can easily happen to anyone. These tracking devices can remain active for months and even years without being detected.
And thank you, and good afternoon, Senate Committee on Judiciary. I am Selena LaRue Hatch. I am the Assembly Member for District 25 in Northwest Reno, and I am proud to be here co-presenting with my colleague because this is a bipartisan issue. This is a concern that affects you regardless of your party, regardless of where you are from. I am very concerned about privacy. I'm very concerned about protecting victims of stalking and abuse. And so I agreed to sign on to this bill and to work on it. So we are going to take a moment and we're just going to walk you through the bill. It is relatively short, But the purpose of this bill is to prohibit an individual from installing a mobile tracking device. So if we look on the bill, there is just one section, subsection 1, says a person commits the crime of unlawful installation of a mobile tracking device if the person knowingly installs, conceals, or otherwise places a mobile tracking device in or on the motor vehicle of another person without the knowledge and consent of an owner or lessor of the vehicle. Now, I just want to make very clear, this does not affect fleets or leases or rental cars, because obviously the owner would know about tracking devices placed on those cars. We also had a question in Assembly Judiciary, which I just want to head off now. This does not prohibit you from putting a tracking device on your child's car if you so choose. If you have a minor child, whether they paid for the car or the insurance themselves, you technically own the car. Unless they are emancipated, they cannot own the car in their own name, and so you would still have that right. It shouldn't interfere with any parental rights in this regard. If you have an adult child, I'm going to give you some bad news that you can't track your adult child, but that might be a personal relationship thing that you guys can talk through yourself. There are some exceptions that we put in there. So I guess there's one exemption. A law enforcement officer can install a tracking device pursuant to a warrant or court order. As we are going to see, many states have adopted this language. That is very common language across those states. I know that there is an amendment that is looking to address that, but I would like to say we actually did some research. There have been no cases of law enforcement needing to use a tracking device without a warrant or court order so far, and every time they have used that, they have gotten a warrant or court order, and so we felt like this language allows them to still do their job, which we want them to be able to do, while also protecting individuals. And then it has the punishments. So a first offense is a misdemeanor, second offense is a gross misdemeanor, and then the third is a Category C felony. And then, just to be clear, there's a definition for mobile tracking device. This includes Apple AirTags, it includes GPS trackers, basically anything you're using to track another individual without their knowledge or consent. And then I'm going to pass this to Serena Evans, who is going to speak to the other side of this bill.
Good afternoon, Chair and members of the Judiciary. For the record, my name is Serena Evans, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. When we were asked to get involved with this bill, I immediately reached out to our direct service providers across the state to hear about the effects that this bill would have on victim survivors that they serve. Today, I'd like to share with you all just a few of the horrifying stories that I received back. One system-based advocate shared that several years ago, she had a client whose case was not taken seriously because it seemed unlikely that she was being followed along with her minor children. Many times she would find her perpetrator following her in the car, including out-of-the-area, non-routine car trips. Whenever the police were called, he disappeared. This victim survivor took the initiative to have her car searched for tracking devices. It took a diligent detective and specially trained police department tech personnel to find the tracker. When the perpetrator was finally arrested, multiple trackers were found inside the vehicle. This advocate shared the significant trauma this victim survivor and their children experienced and how terrorized and unfortunately unbelieved they felt. An executive director of a Southern Nevada program shared that a handful of victim survivors at their confidential shelter have been found due to vehicle tracking devices. Another advocate shared that one abusive partner came to the shelter and took the victim survivor's vehicle because they had an extra set of keys, despite the title and ownership of the bill lying with the victim survivor. This particular victim survivor's job required traveling during the workday. By taking their car, the perpetrator was deliberately inflicting fear, asserting power and control, and sabotaging the victim survivor's employment and financial stability. These stories are just a few of many, but they are not uncommon. Abuse is founded on creating power and control, and perpetrators of domestic violence and stalking are particularly strategic and cunning. We need bills like this one to intervene with predatory abusers' ability to keep tabs on their their victim survivors. My apologies.
So just to make clear, we discovered this because of a very high-profile couple of cases in Reno, but this is for everyone. I think most people that I've talked to, certainly my reaction when I saw those stories was, wait, that's not a crime already? I think most of us assumed that was illegal, and so this bill is about protecting everyone. And I happen to believe that most Nevadans value their privacy very highly, and so we want to make sure we are ensuring that we're doing everything we can to preserve that.
So as you can see, we would not be the first state to do this. There's 26 states that have already implemented this protection. And actually, as of about a week ago, Indiana passed a bill unanimously, 92 House members and 45 Senate members. So Nevada would become the 28th state to pass legislation implementing these protections.
And that is the conclusion of our presentation, and we stand ready for questions.
All right, questions from members of the committee. We'll start with Senator Hansen.
Thank you. Enjoyed the presentation, and I'm co-sponsor on the bill, so I think we're all on the same page. Although you brought up an interesting point that I hadn't thought about. As my wife and I are married, and she's very beautiful, and I'm suspicious as a man that maybe my wife is running around on me. And we both co-own the automobile. Am I allowed to place a device on my own automobile to see where my wife is possibly going, or would that be a violation in this law?
As long as you own the car, you can place a device in it.
Okay, so it'd be, since we're married, we're co-own, you know.
Yes.
Okay. I was just curious.
So you'll be able
if
to
we're-
follow her.
What if we're just living together?
It's the owner of the vehicle. As long as you're an owner of the vehicle, you could
And
do
if you
it.
could put
But-
your name on the record.
Oh, sorry. Jill Dickman, for the record. But you would have to be an owner of the car to be legally able to do that.
Okay, very good. Just I got that after your comments. Oh, that's interesting. So, no, I think the bill's a great idea. Now, the amendment from law enforcement, have you guys had a chance to see it, and do you consider it a friendly amendment?
We have had the chance to see it. Because we're having it as a separate hearing, I don't know that it is a friendly amendment right now. I think you guys are going to discuss it and see how you feel. That amendment was rejected in the Assembly, and so we will have to go through a whole bunch of extra process if it is accepted here.
Okay, very good. No, they came and saw me, and some of the things seemed reasonable, and I thought, well, so we'll hear what they have to say.
Jill
But at
Dick-
the moment, it's not considered a friendly amendment.
Well, Jill Dickman, for the record, this is not the same amendment that was rejected by the Assembly.
Oh,
And
okay.
so it's a little bit different, and it works a little bit differently, and for me, it is not unfriendly.
So Selena LaRue for the record, let's just clarify what we just muddied up, which is we're still working on the language, and we are working with our partners, and we're still trying to get it dialed in, and we're going to take direction, I think, from this committee as well.
Very good. I may
Yes.
have jumped ahead in the hearing anyway, because the law enforcement folks, I'm sure, will come up in a little bit to help, clarify that. So, thank you, Madam Chair.
Other questions? Senator Stone.
Thank you, Madam Chair, and thank you to both Assemblywomen for bringing this forward. I think it's very important to respect privacy, but I just have a couple of concerns. A lot of us are dealing with our parents that are living longer than their parents did. And so I had a situation with my father that had Alzheimer's disease, and but he was still able to drive, although towards the end he was getting more confused. And I remember getting a phone call from a law enforcement agency that they just picked up my dad, and he was 60 miles away from his house, and he was confused about where he was and where he was going. So in a situation like that, where I want to keep track of a elderly parent that is having cognitive issues because of Alzheimer's disease, many times they're a little defiant, and especially when you try to take their driver's license away, they go a little berserk on you. So if I told my dad I'd like to put a device on your car to keep track of where you are so I can make sure you're safe, and he says no, what do I do?
Jill Dickman, for the record. And honestly, the original bill, I had asked for an exemption for someone who was in charge of someone who had Alzheimer's or some sort of cognitive decline. And I'm not sure, was that in the original bill? I can't remember. Apparently LCB did not add that part. So if this is something we're interested in adding, we'd certainly be open to it.
I would respectfully ask that you consider it. Again, people are living longer. Dementia is a very common problem. The responsibility usually falls on the kids to try to take care of their parents, and we all want to make sure our parents are safe and protected, and keeping track of where they are can be very important. And so I think some amendment that's narrow, protecting parents that are basically custodial overseers of their parents' well-being, I would hope could be considered as an exception. And then I do have issues with the exigent circumstances that I think we're going to have another discussion on here today. So I'll save that discussion for when we hear from the opposition, but I have strong concerns about that as well. But thank you. I appreciate the spirit of what you're bringing forward. It's going to protect women, and it's going to protect men and children in Nevada, and I really appreciate it.
Other questions? Senator Krasner.
Thank you, Chair. I appreciate you bringing this bill because this is something very timely, and it was just in the Reno Gazette-Journal newspaper yesterday regarding 2 elected officials who have had tracking devices placed unknowingly on their vehicles. I have researched the law on this, and the law varies a little from state to state. However, the United States Supreme Court has made it quite clear that law enforcement must have a warrant to place a tracking device on anybody's vehicle. So I would ask that you would uphold what the United States Supreme Court has ruled in regards to the Fourth Amendment privacy rights of citizens. And I would also hope that you would, just consider the Fourth Amendment protections that our founding fathers put in there for all of us in the Constitution. I like the bill like it is, but it's up to you. Thank you.
And Assemblywoman LaRue Hatch, for the record, that is the exact discussion we had in Judiciary, and I think that's why we don't have agreement on an amendment right now. And I know we are going to have, there's a lawyer, at least one in the back of the room, that's going to come up and talk about the Fourth Amendment, I'm sure. And so that is why I think we're having a separate discussion on the amendment, because I think there is disagreement there, and we want to make sure we're not blowing up the Fourth Amendment with a bill that is otherwise good intentions.
Or overruling the United States Supreme Court. Thank you.
Other questions? Senator Orenshaw.
Thank you, Chair, and I want to thank Assemblywoman Dickman, Assemblywoman LaRue Hatch. I, too, had read the newspaper stories out of Northern Nevada and was shocked when I heard it was not already against the law for someone to do this. So I really appreciate the bill, and I do think I like the bill as is. The one question I have about the penalty section, the sub 3, is there any time limitation? Like, I know we have some statutes that say, the third offense is a felony in 7 years. Would this be just for the offender's whole life? Like, if this first one's a misdemeanor, then a gross misdemeanor, and then if they the third time try to illegally track someone, then it would go to that category C felony. There's no time, like 7 years or anything like that in the bill.
Assemblywoman LaRue Hatch, for the record, you are correct. There is no time limit on there.
Okay.
And we discussed that in Judiciary. We just felt that if someone is tracking someone without their knowledge and consent, that's a concerning behavior, and there was no appetite to add a time limit in the Assembly.
Okay, thank you, Assemblywoman. Thank you, Chair.
Other questions? Senator Wynn.
I know that there's a proposed potential amendment that we would be considering, and obviously it's something that it sounds like there were some discussions about this piece regarding law enforcement. When we talk about how it doesn't apply to a law enforcement officer who installs, conceals, or otherwise places a mobile tracking device in or on a motor vehicle pursuant to a warrant or court order, Are there circumstances, and maybe this is a question for law enforcement when they come up, where I'm trying to gather a scenario where they would be putting a tracking device on a vehicle without a court order or warrant or any one of those things. Did any of that come up during your conversations?
Jill Dickman for the record. Thank you for the question. And yes, it did come up in discussions. It does happen infrequently that, say, someone was kidnapped and an officer sees the car, but they don't have time to get the court order before they, would be able to arrest that person. And so they can run up and put the tracker on the car and then get the court order. But, I think the people who have the amendment would be able to speak much more clearly to that.
Yeah,
And if it's possible, Chair, to ask questions, because I wasn't aware that our law enforcement officers carried in their bag of tools, tracking devices. So I'm curious.
Yeah, and Assemblymember LaRue Hatch for the record, like I said, we talked to LCB about this. They said they couldn't find a single case where that had occurred. They said that most of these other states just say warrant and court order and that they are able to do their jobs in that way. Law enforcement does have that example that they are going to come up and bring, but I would leave that to you to ask those questions when they come up.
Other questions from members of the committee? All right, not seeing any. I have a couple. And, I would like to say that I do like the intent of the bill. I personally had a case back when I was a prosecutor, a domestic violence case involving a tracker that was installed on a car. And we were not able to charge that offense. Or there was no offense to charge. We were able to charge the stalking offense because of other behavior that had gone on with the tracker, but not the tracker itself. And that was very disturbing to the victim in that case and to me. And so I do think also that it's important to recognize that we're talking about cars, and cars have a lot of special properties, one of them being that they're highly mobile, another one being that they're often in public places where everybody has access to them. And so I think that with respect to differentiating between things like children and elderly parents and other people whose care we might be in charge of, we have other tools to develop relationships with them and to keep tabs on them that are simply absent when you're talking about somebody leaving their car in a parking lot, at their place of work, at their place of worship, even in the driveway of their own home, and anybody can walk by and install a tracking device, which, by the way, are incredibly difficult to find. I also have, I won't call out any particular law enforcement agencies, but I happen to know of one that has lost a tracking device that they placed on a car and then they couldn't find it again when they went to retrieve it because they're so small and difficult to detect. So all of that being said, I do want to talk about the amendment because we are going to have law enforcement up here to discuss the amendment. So I just want to start with, kind of a baseline. What is your understanding of the remedy for a Fourth Amendment violation?
So you're asking, pertains to this bill, what is our proposed language, or?
No, I'm asking you, when someone's Fourth Amendment rights are violated, what's the legal remedy for that person?
Assemblymember LaRue Hatch, I'm not a lawyer, so I am probably going to defer to legal on letting us know what the remedies are, unless my colleague knows.
Jill Dickman for the record. I am not a lawyer either, and so I really wouldn't know how to answer that question.
All right, I'll answer it for you.
Thank you.
When someone's Fourth Amendment right is violated, their legal remedy is to have the evidence suppressed. Okay? And so when we're talking about allowing law enforcement officers to insert tracking devices on a vehicle, if they do that without a warrant today under United States v. Jones, which I assume you've read, right?
Chair, we did not read that in preparation for this hearing today.
Okay, so you're not accepting the law enforcement amendment, but you haven't read the Supreme Court case on this topic.
Assemblymember LaRue Hatch, Chair, I don't know that we were prepared on this amendment in that we were told it was a separate hearing and that it was going to be with law enforcement. And again, as I said, we are juggling many things with the Assembly and with our Judiciary Chair in the Assembly and making sure the Assembly will concur on all of these things. So again, I didn't say that it was unfriendly in that we are completely rejecting it. I just said I didn't know the logistics because you said it was a separate hearing, and I'm a freshman and don't know all of the details of a separate hearing on an amendment.
Jill Dickman for the record. Thank you, Madam Chair, because I am very open to this amendment. So,
I understand. Thank you. And so I'll simplify this in two ways. First, I want to ask, is it your intention that if a law enforcement officer in the course of their duties installs a tracking device, which they believe that they are legally authorized to install, and it turns out that they were not, and when I say it turns out, I mean legally. There are a lot of ways that we can learn that something was unauthorized. It could be that a warrant is not upheld in court. It could be that the evidence is suppressed for other reasons. It could be that it was a violation of policy that is only later discovered. It could be that it was an unlawful use of a tracking device because the vehicle wasn't owned by the person who they thought it was owned by. It could be a defect in the warrant. It could be any number of things. Is it your intent that if a police detective, believing that they have the authorization to install a tracking device, installs it, later learns that they did not have the authorization, but they were acting in their official capacity, do you want them to be held liable for a crime?
Jill Dickman for the record, absolutely not.
Assemblywoman LaRue Hatch for the record. I don't want them to be held liable for a crime, but I do agree with Senator Krasner that I do want to make sure we're in line with the Supreme Court. I do want to make sure we're defending the Fourth Amendment, and I want to make sure we're very, very careful with this language that we are doing so.
All right. That sounds like a good baseline we can all work from. Any other questions? Senator Harris.
Thank you, Chair. I have a question similar to what the chair asked, but I will make it a little more narrow. So, is it your intention that tracker on the car, that they be held liable under this bill?
Assemblymember LaRue Hatch for the record. It is our intention that law enforcement continues to have the same rights vis-a-vis GPS trackers as they currently do. And we are trying to narrow in this language to maintain the current standards on tracking devices.
Jill Dickman for the record. Yes, I agree with that. This bill has nothing to do with trying to change anything police officers are able to do. And that would not be our intention in any way. And so with probable cause, I would say I would hope that they would still be able to do this with probable cause.
Thank you for that. If I could just do a quick follow-up. So I think that some of the issues here are that when a tracking device is improperly installed by a police officer is generally in a very long and robust list of case law, and that we traditionally, as the chair mentioned, the remedy for that is to exclude the evidence, not to charge the police officer with a crime. And as currently drafted, if a police officer has probable cause that a crime has been committed and they put a tracker on, they would be guilty of a crime under this bill. And if that is not the intention, then some type of tweak needs to be made.
Assemblymember LaRue Hatch, I think you just summed up what our intentions are, which is the normal course of events, suppression of evidence. That all stays the same. We are not trying to create a new crime that our law enforcement officers would be subject to.
Jill Dickman for the record. This bill had absolutely nothing to do with law enforcement. We wanted to exclude law enforcement from any consequences of this bill. That was my intent.
And just one last one before my friend over here to the left jumps in. Then I think what we may need to do is ensure that to ensure the current structure remains in place, we can't mess with it, right? And so the best and shortest, straightest line to that would likely be to exclude law officers or police officers who are on duty in the commission of their job, right? Now, if you're a law enforcement officer and you're stalking your girlfriend, fine, right? Then it should apply to you as a regular citizen. But if you're doing your job as an officer and you run afoul of this law, we have, I think, remedies in place through the court system. And to maintain that, we may want to look at just peeling this back a little bit and ensuring that law enforcement officers are not caught up for not following the Fourth Amendment perfectly, right? That should not be a crime. And I don't know if y'all know where I sit generally politically, but if I'm up here defending law enforcement, right, you got me on the same side as the DAs, we're in trouble.
Senator Hansen, go ahead.
Okay, I think we're way off in the weeds a little bit on this because as a sponsor on the bill, look, I agree with you. Remember, with law enforcement, I'm sure the amendment now is going to probably get a more fair hearing because we're obviously none of us want to go after guys that have reasonable levels of probable cause. And with any crime, you do have mens rea, criminal intent before a prosecution could occur. So before one of these guys could be prosecuted for potentially unintentionally violating the law, the people who want to prosecute them would have to prove that they intentionally, knowingly broke the law. So I think we are pretty much covered already, but I can see where my colleagues are going with this. We want to make sure that when there's a reasonable reason for the cops to need to use one of these tracking devices, and then all the steps that the chair brought up may come into play, that there is not some possible way for somebody to then go around and in the absence of mens rea, criminal intent, go after a cop. So I think that's your intent from the get-go. So when we hear this amendment, which I'm sure they're going to bring up here in a minute, we all are on the same understanding. Our goal here is not to come up with some reason to possibly criminalize police behavior that is done with good intent, okay? That they had probable cause, or even if they had, they're waiting for the search warrant approval, they're following somebody that may have kidnapped somebody, et cetera, et cetera. We want to make sure that there is no way that they would face criminal prosecution in the absence of an example like she gave. If they're doing this to follow their girlfriend, then sorry, your normal police protections go away, and you do have criminal intent in that case, and you could be prosecuted even if you were a cop. Correct?
Jill Dickman for the record. Thank you, Senator Hansen. I wish I could have said it that well.
Very good. Thank you.
Oh, okay, Senator Stone.
Last one, Madam Chair. For our legal counsel, can you just opine on existing law today? Is the Nevada law silent on exigent abilities for our law enforcement to put devices on cars that they allegedly feel are timely and important, that can't wait for a search warrant, or is it allowed under existing Nevada state law that under exigent circumstances that they can in fact put those on vehicles?
Carly Okrent for the record. I'll see if I can concisely answer your question. So under existing law, the status quo is that attaching a GPS tracker to a vehicle is a search under the Nevada Constitution. And so with regard to whether or not a warrant would be required, that would be governed by existing Fourth Amendment case law. So it'd be specific to each particular circumstance.
All right. Any other questions? All right. Thank you so much for your presentation. We will invite the sponsors of the amendment up now to present the amendment and answer any additional questions.
Good afternoon, Chair Scheibel, members of the committee. Jason Walker, Washoe County Sheriff's Office. Happy to be here to discuss hopefully our still friendly amendment. Although I do like the format, open it up for questions from both sides of that. I really like the conversation as we're starting. And again, Jenny Noble from the Wash County DA's office is going to be my phone a friend, my SME on Fourth Amendment search and seizure. Having worked at the Washoe County Sheriff's Office for 17 years, I have an operational knowledge of it. So she's here as my matter expert on that. And again, we wholeheartedly support criminalizing use of trackers by private citizens without consent. Our concern lies with subsection 2 of the bill's language, providing an exemption for law enforcement pursuant to a warrant or court order. It is our understanding that the purpose of the bill is to prohibit the use of trackers by private parties while not altering the ability of law enforcement to use trackers pursuant to present law. However, the Supreme Court has several recognized exceptions to warrant requirements regarding exigent circumstances. Consider this. In throwing worst-case scenarios out amongst the coalition, this is the worst one that we came up with. A 12-year-old girl is kidnapped outside of a middle school by a stranger. The kidnapping is caught on surveillance, and the perpetrator is identified as having a gold Toyota with license plate so-and-so. The following day, an undercover officer, and it's the undercover officers that have tracking units as part of their kit. They are the ones that are chasing the worst of the worst that are out there. It's not the standard uniformed police officer that carries any of the tracking devices. It's the ones that are out there looking for the worst of the worst. Undercover officer observes a vehicle with the same license plate at a gas station. Goes inside, observes a perpetrator in line to buy a box of super crunchy Gardettos and a box of condoms. The girl is nowhere to be seen. The officer quickly runs to his car, obtains a tracker, slips it onto the perpetrator's vehicle. The officer is rightly more concerned about finding the girl than immediately arresting the perpetrator. The perpetrator exits the store moments later, gets in his car, and drives to a cabin in the wood. Police are able to follow him using the tracker, save the girl, and arrest the perpetrator. If this bill were to pass as written, that police officer would be committing a crime by placing that tracker on the vehicle without a court order. It is correct that applications for search warrants can and are often made telephonically. Even given that option, there are circumstances such as the above hypothetical, and again, it may never happen, but in the event that it would, that would be the worst thing that we can think of, is we're unable to do that. We wouldn't have the 10, 15, or 30 minutes it would take to obtain a telephonic search warrant. For instance, the Supreme Court allows police to enter a home, a person's most private place, without a warrant under exigent circumstances. All we're asking for with this amendment is to add the language of probable cause. It changes nothing else. We want that status quo to be there. And again, in going to the amendment, Section 1, subsection 2, adding the language of peace officer as opposed to police officer, and I'll just read it. The provisions of subsection 1 do not apply to a peace officer who installs, conceals, or otherwise places a mobile tracking device in or on a motor vehicle of a person who the police officer has probable cause to believe is committing or has committed a crime, or pursuant to a warrant or court order. That is all we're asking with this, still again, hopeful, friendly amendment. And with that, I will turn it over to my subject matter expert, Jenny Noble.
Good afternoon, Chair and members of the Judiciary Committee. Jennifer Noble on behalf of the Nevada District Attorneys Association. I did not expect, when I first saw this bill, for it to become so intense in terms of Fourth Amendment analysis, but I'm actually really glad we're having this conversation here today, because it's important for everybody to understand how this works. So the Fourth Amendment, the United States Constitution, provides protection against unlawful searches. With regard to the Fourth Amendment, there are court-created doctrines by the United States Supreme Court that create exceptions to that rule, and they are narrow exceptions. So I want to make clear at the outset that nothing in this amendment, and in none of our discussions have we ever indicated anything other than a desire to keep our constitutional rights for Nevadans where they currently are. And that is that any search must be supported by probable cause and a warrant unless it falls within one of the narrow exceptions to the warrant requirement as outlined by the United States Supreme Court. That's what we'd like to make sure continues to be the case. I'd like to thank the sponsors for their discussions with us. We are trying to make sure we all have the same rights after this bill is passed that we did before it was passed with regard to search and seizure. We're in strong support of the policy, which as we understand it, is to ensure that people aren't tracked without their knowledge and consent, because to do otherwise is an invasion of privacy. No one should have to tolerate that. And the United States Supreme Court made that very clear in 2012 with United States versus Jones, which was referenced by the chair. That found that the placement of a tracker is a search for purposes of the Fourth Amendment. We are not trying to say it's not a search. We could say that all day long, and that would not be the law. That would violate United States Supreme Court precedent. Our purpose isn't to narrow or expand constitutional rights. I'm sorry to keep saying that, but I just want it to be clear. It's for them to remain the same. Tracker placement requires a warrant, absent narrow exceptions to the warrant requirement, which include exigency or emergency. To be clear, it is judges, not DAs, not law enforcement, who ultimately decide whether exigency or another exception to the warrant requirement applies to a situation, and this would be no different. If law enforcement miscalculates in their assessment of exigency, the exclusionary rule would apply and operate to have any evidence emanating from that invalid search to be suppressed in court. That is the remedy. It shouldn't be a criminal remedy, because sometimes law enforcement might apply for a warrant. The court grants a warrant, and another higher court says, no, we don't think you should have granted that warrant. There's an exception for that. It's called the good faith exception to the warrant requirement. We can't provide for every instance, and so we have to have an ability to make room for United States constitutional law in this. At the same time, let's protect our Nevadans and make sure that they're not harassed in this way, that they're not stalked in this way. This is such important policy, and we remain very hopeful that this bill can go forward informed by that necessary acknowledgement of our state constitution, of our United States constitutions, because Nevadans deserve no less, and private individuals deserve to be free from this this type of harassment. I wanted to add, and I know the LCB works very hard, the sponsors have worked very hard, we've been trying to work hard to come together on this, that according to our research from the National Council of State Legislatures, a September 2022 article indicates that most of the new laws, very similar to this law, provide for an exception for lawful use by law enforcement. Two examples are Utah and Texas. Texas says that this section doesn't apply to a peace officer who installed the device in the course of a criminal investigation or pursuant to a court order. Utah says this section does not apply to a peace officer acting in the peace officer's official capacity who installs a tracking device on a motor vehicle in the course of a criminal investigation. So this is not something that unique that we're asking for, and the mere fact that we can't give you an example of a state in which this was passed, similar legislation was passed, and then somehow the police can do something and something horrible happen is because these laws are recently passed and because it doesn't happen that often. That's why they're exceptions. But we have to have the ability to have them. The opportunity for this type of discussion about our Constitution is so important, and I thank Chair Scheibel for allowing it, because unfortunately, it was not allowed over on the Assembly side. It was regrettably denied to us by the leadership of that committee. We hope to continue working with the sponsors, and I'm here to answer any questions that you might have.
All right, Vice Chair Harris.
Thank you, Chair Scheibel. Mr. Walker, Chuck Calloway would be very impressed with your scenario developing skills. Yeah. My question is, in your scenario, why not have the officer simply follow the car?
Jason Walker might be seen. That would be, if you are too close, it's too late at that point to spook the guy. I mean, that's my honest answer. A tracker, place it, move away. That tracker tells you where he's going to go. I think the best thing to do is not push an incident, but maintain it as it goes. And I believe that that's the safest play on that.
Okay, so we're talking about an undercover officer, though, in your scenario, right? So, I mean, it's probably an unmarked car, and, I mean, I've never been trained in tailing detection, so I think, I mean, is that a thing? I guess I'm trying to get at, you know, the scenario that you could come up with. It seems to me that there are other tools that might be available to law enforcement, especially given that your public movements aren't protected at all, right? That's not a search to kind of like follow someone. And so I think the safer thing to be would, and not infringing on someone's rights, would be to simply just follow them to where they might be, call back up, or whatever the case may be, right?
Jason Walker, I don't disagree with you, Senator. That's a great point. I see the other point as well.
No, one last follow-up, and then, well, go ahead, please.
Well,
go ahead.
I was going to follow up with, I guess the question is, would you want that officer to be criminally liable for making that judgment call to put the tracker instead of following the car?
Jason Walker, absolutely not.
Okay, so yes, that's where I was gonna that's where I was gonna go next in that scenario. If right now, under the current state of law, a officer has probable cause, without this bill, if an officer has probable cause that a crime has been committed, which I would suggest your scenario presents, right? You've got the license plate, a description of the guy. You have probable cause this is him. Would a search be allowed?
Jennifer Noble, for the record, under the current language of this bill, a search would not be allowed.
Under the current state of the law?
Under the current state of law. Thank you for the correction. Under the current state of the law, if you had an exigent circumstance, you could make a search. You could place that tracker there. But if you were wrong about that, any information you gain from that search is going to be suppressed later on. But you're not going to be criminally charged.
And that would then be the case if we do not accept the amendment. The new state of the law would be, not only would the evidence potentially be suppressed, but the officer would be subject to potential criminal penalties.
Jennifer Noble, for the record. Yes, Vice Chair Harris, we are agreeing in an unusual amount today.
Let's keep it going. All right. Thanks, y'all. Thank you, Chair.
Senator Orenshaw.
Thank you very much, Chair. And my question, Officer, is in your experience as an officer on the ground, when you've maybe sought a telephonic search warrant to put a GPS tracker on a car, has it been turned down very often? And if I could indulge me, Chair, with a second question, have you, in your experience, had instances where you've had to bypass seeking that telephonic search warrant and had to try to put that tracker on a car before you sought that search warrant?
Jason Walker, the applications for warrant to place a tracker have not been turned down. This extreme instance has not come up, but I don't want it to come up and not have the ability to do it.
Thank you, Chair.
Senator Wynn.
Thank you. I'm always at a loss for words when we have these outrageous like scenarios that we're using as potential examples. I'm having some flashbacks to when I tried to initially brought Assembly Bill 116 regarding decriminalizing traffic, and there were scenarios about law enforcement officers not being able to like stop people because there were severed heads on like the seat next door. So I don't necessarily agree that we should make policy decisions in statute based on like wild, crazy hypotheticals that are there. So I'm just, I'm concerned that the protections that we're seeking to further expand in there. I mean, are there any other examples that you might be able to give that are not so like choose your own adventure like style? And maybe that's something that another law enforcement partner might be able to expand on.
Jennifer Noble, for the record, through you, Chair.
Oh, you can go direct.
Thank you. Senator, when your point is well taken, but I would say that examples always sound outrageous until something happens to your family and we need to find your kid or we need to find somebody quickly and we have to do something without a warrant. I can't give you a precise example. I don't know if one will ever happen. I don't know, and I hope it doesn't. But I don't think that this bill, I don't think the intention was to narrow or exceed the scope of current constitutional protections on Nevadans, and I don't see any reason for it. We can easily keep the current state of the law without holding police officers criminally liable when they do their best to assess an exception to the warrant requirement. And if they don't, the courts will deal with it and they will exclude the evidence.
Beth Schmidt, for the record, SCHMIDT. I represent the Las Vegas Metropolitan Police Department. In answer to questions Senator Harris has raised and Senator Wynn has raised, I do want to say that LVMPD has a major violators unit, and we do go after the worst of the worst. And these are not hypotheticals. We are going after bad people. And one of the reasons that we put those trackers on, and it is the exception that we do this, but if we have a guy who we know has committed a heinous crime, we do not want to try and apprehend him near a school. We do not want to try and apprehend him in a supermarket, at a 7-Eleven. Well, the reason that we would put a tracker on and the reason that our major violators unit does that is because it is for public safety that we do it. Could we pursue them? Could we get into a vehicle pursuit? Senator Harris, my offer to you has always been to come and do a ride-along. I want you to ride with me, and we're going to... Pardon? Yes. You've done one.
I've done one.
I want you to come with me and do some surveillance while we train surveillance. It is
Absolutely.
extremely difficult to follow people. And I have done this in unmarked cars, and I did this for 3 years when I worked in financial crimes and following people. It is extremely difficult. And in the scenario that was put forth where you have someone who has kidnapped a child, that person is looking over their shoulder. Trust me, it is very, very hard to follow someone. And we train this repeatedly in these units. So when we have someone who is a very, very violent person, we put that, this is the exception to the rule. We will put the tracker on if we have the opportunity, because it gives us a chance to be able to monitor where they're going and try and apprehend them safely to protect society, to protect people. This is not TV where we're going to follow them and get into a pursuit. By having that on there, we're able to use other resources and de-escalate the situation. And we're able to get our air unit up, and then the air unit can follow where they go to. We get them to a place, and we're patient. And we get them, our major violators unit will get them to a place where it is now safe. They are contained. We surround, we call out, we use crisis negotiators, and that's how we get people out. That is why we so desperately need to maintain what we already have. And as written, the bill, it changes the law more substantially than it appears on the surface.
Now I'm down a wormhole. I have concerns about what you just said, because it sounds like you're saying that Metro is tracking people without warrants and without exigent circumstances when they're repeat offenders. Is that my understanding?
Beth Schmidt, for the record. No, the unit that is in charge of trying to find the worst of the worst is called the Major Violators Unit. So if we are able to locate that person in a vehicle, that's what I'm saying. We are specifically trying to find one person because of a crime. And so in that instance, if we see them and we have an opportunity to put a tracker and in order to enable us to safely take them into custody, that was the intent of what I was saying. So we're not running around putting trackers on people just willy-nilly. No. This is a very controlled situation, and you're trying to do it as safely as possible. Does that answer the question?
In those circumstances, you have a known suspect. Is that correct?
That is correct.
And so would you not have already obtained a warrant to be able to like track that person because you already suspect that they are the perpetrator in that crime? And that's not what's suggested in this amendment, which is the person has probable that they're committing, I guess, or has committed a crime. But if you knew they committed a crime, then you probably would have got a warrant.
Jennifer Noble, for the record. Senator, I know, I understand what you're saying, and I know you're a practitioner in this area, and so you know that when we apply for a warrant, or when they apply for a warrant, rather, and has to be with sufficient particularity, if they don't know the vehicle that the person is in, if they don't know what they're wearing, if they can't articulate exactly what they want to do, what vehicle they want to put the tracker on, they can't get a warrant ahead of time. It's if they see them in a vehicle, could be a stolen vehicle they didn't know they had. This is a narrow exception that Metro's describing, and it's one that I would say fits exigency. But of course, that's going to be for a court to determine. But they have to have particularity. If they don't have enough to put in the warrant application, they can't do it ahead of time.
Senator Orenshaw.
Thank you very much, Chair. And Director Schmidt, thank you for giving us your real-world experience with the Metropolitan Police Department down in Las Vegas. Just wanted to ask you the same question I asked earlier. In your experience, has an application for a telephonic search warrant for a GPS tracker ever been denied to you as an officer? And then my second question, if you'll indulge me, Chair, have you had a case where you had to bypass that and go put the tracker on a vehicle before you went and applied for the telephonic search warrant?
So for me, I personally have not put trackers on. So that is a specialized unit that does that. But to my knowledge, no. I spoke with our major violators unit and the sergeant there, and I was not made aware of any that have been denied. And that is because the specificity in the warrant.
Thank you. And if I could follow up, and I understand maybe this is something Major Violators Unit could answer, are you aware of instances where there were those exigent circumstances and they had to put the tracker on right away and bypass the request for the telephonic search warrant?
Yes, there are. And what they do then is once it's placed on, they immediately start to do the paperwork for the telephonic warrant. But the telephonics take a little bit of time to do it and get on the phone with the judge. So they'll place it first.
Okay, thank you, Director. Thank you, Chair.
Senator Hansen.
Thanks, Madam Chair. Now, I got to go on a ride along once. Unfortunately, I was in the back seat, so we won't go on down that one too much. Question on you were talking mainly about you guys in Vegas, but rural people don't necessarily have immediate access to a judge to get a search warrant or whatever, so they have to probably need some level of protection for probable cause, which I think really, as a co-sponsor of the bill and from hearing the comments, I think what we want really is simply to give in line 2 of section 1 some level of probable cause protection to the police short of a full-out warrant or court order. I think that's where we're going. And the question I have, though, is on if the law is passed, as is right now, if I was a sharp defense attorney, I would challenge the admittance of the evidence based on the fact that while you had probable cause, the law requires you to have a warrant or court order. Therefore, this evidence should be suppressed by the court. Even if you found that the individual was a kidnapper, you failed to follow Nevada law, therefore the evidence would be suppressed. As a defense attorney, I would ask the court, this clearly was a violation of the constitutional or Nevada law protections that my defendant rightfully has, and you guys have broken the law by failing to get a court order or a warrant. Therefore, all the evidence in this kidnapping case, for example, should be suppressed, Your Honor. Yes or no?
Jennifer Noble, for the record. Short answer is yes. If I were a defense attorney, I would try to do that. And I might be right because, to some extent, we can't legislate away the United States Supreme Court's requirement that we have a warrant when we place a tracker on a vehicle. And we have narrow exceptions for that. And those should be built into this just like they're built into everything else. But no, I mean, we certainly can't with our statutes just require probable cause and no exigency. We have to have both, or we have to have a warrant, or that's going to be suppressed. It should be.
Okay, well, that's kind of what I'm getting at. Under current law, you guys have a probable cause exception. If this passes without the amendment, that could be challenged. And therefore, the amendment seems friendly to a guy that's a co-sponsor of the bill, but, you know, we'll see where it all goes. But it does seem to me this is a reasonable thing. It is an extreme example, but as you guys point out, there are a lot of nasty cases that are, in fact, extreme examples of horrible human behavior where you may need protections of a probable cause provision in Nevada law to make sure some really sharp attorney doesn't say, sorry, you didn't follow the law. You had probable cause? Yes, but the law doesn't say probable cause. The law says you have to have a search warrant or a court order. Therefore, this evidence should be suppressed, Your Honor. That's how I look at it. But anyway, thanks, Madam Chair.
Senator Stone.
Thank you, Madam Chair. And thank you, Ms. Noble, for giving us a lesson, especially us non-attorneys, on the Fourth Amendment and the constitutionally tested exceptions, which you said are very narrow, but are documented in case law. And what we're talking about is unintended consequences of this bill, right? I mean, we're all in agreement that we want to protect the privacy of all Nevada citizens. So to my Metro friend, does it happen often where you use exigent circumstances to go after a criminal, you end up in a court of law, and a judge says that the exigent circumstances were not valid and suppressing evidence? Is this a common problem in Clark County?
Beth Schmidt, for the record, no.
Okay. So I would imagine this could be a very rare situation, but it could be a life-saving situation. And then we've talked about telephone warrants. How often does Metro have to get a telephonic warrant, and what would you say would be the average amount of time taken to get to the judge, give them the details, get the warrant back? I mean, are we talking an hour? Are we talking 30 minutes? Are we talking 5 hours? Are we talking a day?
Beth Schmidt, for the record, we do, across our agency, in our investigative division, we do telephonic warrants all the time, multiple, daily. Average time, I would say, best case, this is assuming that the judge is available. They're available to us 24 hours, but if they're in the courtroom, we have to wait. I would say best case scenario is 30 minutes, because it's got to be read. It's got to be approved by and read by a second officer. Then it's got to come to the supervisor. The supervisor has to approve it. Then we have to talk to the district attorney, and then we have to call the judge. So that's a best case.
That's a best case.
That's someone who's experienced, knows what they're doing, they're organized, they have all the facts, so they have enough detail in there. And I would say 30 minutes would be your very best case scenario.
That would be the very best, but probably not the average. I would
It is
imagine
not
it
the
probably
average.
takes longer, and there are situations that are acute that if you don't intervene quickly, it could mean the loss of life or morbidity or mortality, murder, rape, whatever. So it seems to me that there's no question the bill has to be amended in some form, because I definitely don't want to put police officers in jail for exerting their rights, if you will, to appropriately apprehend criminals in the operations of their work. And so I'm hoping that we can come together and come up with an amendment that works. I think Ms. Noble's made it very clear, in contrast to what we've heard, that it's specifically written in the U.S. Constitution, the Fourth Amendment. There's no exceptions. We know that there are exceptions, and these exceptions have worked. Not only have they worked, but they've worked without any problems in Clark County, which is the largest county in Nevada, and I know that it's worked in a neighboring state that I used to be involved with without any significant issues. So thank you for answering my questions.
Other questions from members of the committee? I just wanted to clarify two other things, well, maybe three others. Are you aware of anywhere else in statute that requires an actual warrant in order for law enforcement to act as opposed to requiring probable cause?
Jennifer Noble, for the record, no.
Beth Schmidt, for the record, no.
Jason Walker, same.
And the language that's currently contained in the amendment that you proposed, probable that the officer has probable cause to believe that the person is committing or committed a crime, is that also the standard for getting a warrant?
Jennifer Noble for the record. Yes, that's correct, Chair.
So it's kind of circular that in order for a person to avail themselves of the probable cause section of the bill or of the amendment and be allowed to install this tracker without a warrant, they would have to still, all the circumstances would have to be there that would have allowed them to get the warrant. And I think that the last, I don't know, hour, 35 minutes of conversation we've had about constitutional law and the robust case law on this is to explain that very fine difference between having a warrant versus having all of the attendant circumstances of a warrant, which is very important to you as law enforcement officers to be able to do your job. Is that, am I summarizing that correctly?
Yeah, Beth Schmidt, for the record, you are, and these are exigent circumstances. This is not an everyday occurrence that this happens.
Jason Walker, I agree with you, Chair Scheibel.
And so just to further clarify, when we say that a police officer has probable cause to believe that the person is committing or committed a crime, that is not new language invented by you, inserted into this amendment. That is the constitutional standard for a warrant, correct?
Jennifer Noble for the record. That is correct, Chair.
And Beth Schmidt, for the record, that is correct.
Jason Walker, same.
All right. Vice Chair Harris.
Thank you so much, Chair Scheibel. I know that we've had quite a bit of discussion about the Fourth Amendment and when a search is allowed and isn't allowed. And, I think we might want to level set here. And regardless of whether we understand the standards and all the case law behind it, the question I believe that's in front of us is, should a cop be violating a crime if they don't meet that standard for any given reason, right? And so understanding the intricacies is almost, to me, secondary to the issues we're discussing in this bill, right? It's about, regardless of what the Fourth Amendment standards are, has an officer committed a crime by not meeting those standards? And it seems to me that a majority of this committee and even the bill sponsors do not think that should be the case. And so I want to make sure that even though we've got our heads all, scrambled up about, U.S. v. Jones and probable cause and, that's more in the weeds than I think that this committee even needs to get. The decision here is, will officers be criminally liable for violating that standard? Thank you, Chair.
You said it better than I could, so thank you. I don't know if you guys wanted to respond to that. It seemed like more of a comment. Okay. All right. I think we have finally concluded all of our questions. We thank everybody for all of your time spent here today, but we are not done yet. We still have testimony. We will start with testimony in support of AB 356 and invite anybody wishing to give support testimony up to the front of the room in Carson City and Las Vegas. You'll each have 2 minutes. Go ahead whenever you're ready. I'm sorry, we'll start in Las Vegas. There's no one taking a seat in Carson City.
Well, I don't think I need 2 minutes to tell you. I think this is a lovely bill, and I'm very happy when I see people working across the aisle and getting along and doing something that is good for the community. So thank you for your time and your service, and I will vote any way our Senator Stone votes.
Oh,
Always.
wow.
So thank you.
Could you put your name on the record, please?
My name is Susan Profit. I'm the Vice President of the Nevada Republican Club. Sorry, I forgot.
That's okay. Thank you. You can go ahead in Las Vegas.
Thank you. Good afternoon, Chairwoman and committee member. My name is Julie Herford, co-founder of Nevada's CAN, Citizen Action Network. We're here in support of this bill. Just want to thank all of you to help make our state better. Again, we're supporting this bill. Thank you.
Thank you, Madam Chair. Melissa Clement with Nevada Right to Life, just adding our support to this bill. Thank you very much.
And we will go to the phones for support testimony on AB 356.
Thank you, Chair. If you would like to testify in support of AB 356, please press star 9 now to take your place in the queue. Thank you, Chair. There are no callers to testify at this time.
All right. At this time, I will extend the option if anybody wants to come in and testify in a position of support if the bill were amended. And you'll also get 2 minutes to do that.
Good afternoon again, Chair and members of the committee. Jennifer Noble on behalf of the Nevada District Attorneys Association. As I think was probably pretty clear, we think an amendment or something like it is a good idea. What I want to make sure that is not lost in the sauce is that the sponsors of this bill have a great idea, which is to protect Nevadans from people putting trackers on their cars and having their privacy invaded. And the only time that expectation of privacy should be invaded or is when we have a warrant or an exception to the warrant requirement. That's it. And those are rare. We do really appreciate their intentions, the discussions that they've had with us. And I think to the extent that we've had to have a lot of fleshing out today, that is not due to the sponsors. It was just due to probably a lack of discussion and vetting in the prior committee that I hope we can alleviate over here or on the other side if it goes back.
Thank you, Madam Chair, members of the committee. Nicole Rourke, representing the city of Henderson and our Henderson Police Department. Also would like to echo the comments of my colleagues. This is good policy that protects Nevadans, and we certainly want to protect our residents' privacy while also maintaining what our officers need to do their jobs. So thank you for your consideration. We also like to thank the sponsors for their work on this bill.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Pamela Del Porto. I'm Executive Director for Nevada Sheriffs and Chiefs Association. We also support what the policy is behind AB 356, but we are in support of AB 356 amended. Thank you for your time.
Good afternoon again, Chair Scheibel and members of the Judiciary. My name is Beth Schmidt. I represent the Las Vegas Metropolitan Police Department. We want to thank the sponsors, Assemblywoman Dickman and Assemblywoman LaRue Hatch. We are in strong support of the policy of this bill, which prohibits tracking people with a mobile tracking device without their knowledge and consent. We are in strong support of the amendment, and as I discussed earlier, we are neither looking to narrow or expand constitutional rights in AB 356. I also want to thank you, Chair and Vice Chair, for giving the context, for articulating U.S. v. Jones, the Fourth Amendment, and search and seizure. These are all key elements of how we practice as law enforcement officers. They are studied in the academy. They are continually studied. And we take classes, we take exams, and we apply them on a daily basis. That is what gives us our authority. So I thank you for giving us the opportunity to present that context. And I also appreciate both of our sponsors of the bill saying that they want to continue law enforcement to have the existing rights that they have, and it isn't their intentions for us not to be able to continue to do our job as we have been dictated by the Supreme Court of the United States. We are in support of this bill with the amendment.
Good afternoon, Chair, members of the committee. Jason Walker, testifying on behalf of the Washoe County Sheriff's Office in support amended of Assembly Bill 356. And I, like my colleagues, would like to thank Assemblypersons Dickman and LaRue Hatch. I'm looking forward to meeting with them to further work on language for this. And as far as the presentations today, I don't think it could have gone any better. I think that was probably the best approach for that. So tip my hat to you, and again, testifying in support amended AB 356.
All right, I don't see anybody else coming up to give testimony. We've already taken testimony by phone in support, so we will go to opposition testimony on AB 356.
Thank you, Chair. If you would like to testify in opposition to AB 356, please press star 9 now to take your place in the queue.
Good afternoon, Chair, members of the committee. Erica Ross on behalf of the Washoe County Public Defender's Office, testifying in opposition specifically to the amendment this afternoon. If the concern is privacy that we're talking about, this amendment violates the very basis of that claim, being the Fourth Amendment. I know we've discussed that at length, but I want to kind of take a step back and break down where the real issue lies. The Fourth Amendment protects each and every one of us from unreasonable search and seizure by the government. It's the very bedrock of our privacy rights in the country. The amendment that has been proposed goes beyond the enumerated exceptions to the warrant requirement. This will allow a search without a warrant, not where someone is in danger and needs to be saved, but in any and all circumstances in which a crime may have been supported by probable cause. That is contrary to the Supreme Court case law and basic tenets of the Fourth Amendment. As stated earlier, the Fourth Amendment is not absolute. There are enumerated exceptions to the warrant requirement. For example, a law enforcement officer does not need a warrant for some of the following circumstances: a search incident to arrest. Once someone has been arrested, an officer is allowed to search that person and their belongings within their wingspan. Any items in plain view. So in that unlikely scenario where a law enforcement officer sees a severed head in the backseat of a vehicle, they do not need a warrant to search that vehicle. Most importantly, in this scenario is the exigency circumstances, and this is otherwise known as hot pursuit. So this is when a law enforcement officer requires immediate attention, such as preventing destructions of evidence or escaping a fleeing felon. So here's a common law school hypothetical. John Pirro is super hungry and he sees Senator Wynn eating cookies and he grabs the cookies forcefully out of her hand. So he's now committed a robbery, but thankfully John Abel has seen the whole thing and starts chasing John Pirro as he's eating all the cookies. He's able to enter John Pirro's home to stop him from destroying that property. These are the scenarios that we're talking about here. I want to briefly address the Supreme Court decision in United States v. Jones. So the facts of that case differs from the circumstances the sheriff's office has raised, and that's specifically in Jones, there were no exigent circumstances or a hot pursuit. The defendant was suspected of being part of a complex drug trafficking operation, and there was evidence supporting a warrant that was sought and granted to track the individual for 10 days. The issue arose where the officers continued tracking the individual after the time permitted in the warrant had expired. And importantly, the court found that there was no exception to the warrant requirement in that circumstance because there was no, for example, hot pursuit or exigency to prevent another crime from being committed. Since we're staying on hypotheticals today, I want to propose a more likely hypothetical scenario that will take place if this amendment is adopted. Let's say that the police suspect you of hunting without a license, and an officer now has probable cause, they believe, that you are doing that. And the officer, without judicial review, can now put a tracking device on your vehicle and track you to your home, to your school, to your church, to your family members' homes, and where the government is going to have that much access to your most personal relationships and life, there must absolutely be judicial review. In the scenario that was provided by the Washoe County Sheriff's Office, there is nothing in the original bill that would preclude an officer in that exigent circumstance from placing a tracking device on this kidnapper's car and tracking that kidnapper. Nothing would preclude them from doing that. But by adopting the amendment, an officer will now be able to track each and every one of us without any judicial review, and when another crime is or another life is not at danger. In Jones, the court recognized how unbelievably personal information can be gleaned from a tracking device. And when we are talking about that most personal information, there has to be judicial review. The original bill will not preclude the scenario where, and I'll note, this is hypothetical. No one has been able to point to a circumstance in which this has actually happened. But if a kidnapper kidnaps a 12-year-old girl, there is then probable cause to put a tracker, there is an exigent circumstance to put a tracker on that device. I urge the committee to pass the bill as originally drafted. This amendment is incredibly dangerous. Thank you.
There are no further callers to testify at this time.
All right, then we'll go to in person here in Carson City.
Thank you, Chair. John Puro from the Clark County Public Defender's Office. I'm just going to say a few things, right? Not only am I a Clark County Public Defender, but I was also the president of Nevada Attorneys for Criminal Justice, which represents all the criminal attorneys across the state of Nevada that are worth their salt. The world is vexatious enough. I don't have time for hypotheticals and the proponents of the amendment, because that's the only part of the bill that I oppose, the amendment. I think it's a fine bill written, and I don't think anybody's trying to criminalize police officers. If they are, the sponsors have specifically said they're not, and I think maybe we just limit this bill to private persons then, and then we just remove all that and we leave the Fourth Amendment where it stands. However, this amendment as it is, significantly, as Ms. Roth said, weakens the Fourth Amendment. And I don't think that's Sergeant Walker's intent. I don't think that's Jenny Noble's intent. But how it's written will weaken the Fourth Amendment. U.S. v. Jones lays out a few things. One, a car is an effect, which makes it subject to the Fourth Amendment. And two, placing a GPS tracker on a vehicle is a search because when the government obtains information by physically intruding on our constitutionally protected areas, a search occurs. A search and seizure without a warrant is per se unreasonable. Why do we have that in effect? It's to protect all of us, not just criminals, not just these wild hypotheticals that were thrown out. The proponents of the amendment could not cite a single real-life case where they applied a tracker with exigent circumstances and the evidence was suppressed or a case dismissed. Why? Because it doesn't exist. And I don't think I know a single judge that would ever suppress evidence of an officer putting a tracker on a car when a 12-year-old girl is missing, where that evidence would get suppressed. I just don't think that's a real scenario. But when we talk about the Constitution, we got to throw out these hypothetical boogeymen to ameliorate our protections, as if the Constitution is a technicality. And it is not a technicality. It's so frustrating when we treat it as such. This bill says get a warrant. That's the right way to go about things. And when exigent circumstances apply, our United States Supreme Court case law says you can do it without a warrant. That scenario would be exigent circumstances. Any other wild hypothetical scenario will likely be exigent circumstances. So I wholeheartedly ask this committee to not accept this amendment and quit letting a perfect piece of legislation, which we cannot craft, that would address all of our constitutional situations, be the enemy of a good piece of legislation as it is. And one more thing. Police officers get a good faith exception that none of us citizens get. They are actually trained in the law, and when they screw up on the law, the court says, it's okay, you did it in good faith. But not us. We are not trained in the law. Regular citizens do not watch these committee hearings. So when you make a mistake in the law, we don't get the good faith exception. We get criminalized. So the police have enough tools in their tool belt without ameliorating the Fourth Amendment with their proposed amendment here. Please pass it without the amendment.
I think we have a couple of questions, and I'm going to go first. I just want to clarify what I think I heard you say, which is that you would be in support of an amendment with language something like, this does not apply to peace officers who install a mobile tracking device in the course of their lawful duties.
Not the lawful duties. I think the lawful duties creates an exception that is not in our current case law. I think and I haven't even talked to the sponsors about this, but I think just eliminating Section 2 altogether, taking the police officers out of this bill altogether and leaving it, putting private person in Section 1 covers the situation that we're trying to cover. And then we get out of all this deep Fourth Amendment territory where we're trying to ruin the Fourth Amendment and Article 1, Section 18 of the Nevada Constitution.
But then, if we put private citizen in Section 1 and removed Section 2, then wouldn't that open up the door for anybody who is not a, quote, private citizen to install trackers anywhere and everywhere that they wanted to?
Well, who's not a private citizen, aside from law enforcement?
That's my question. That's part of my question. But if it's law enforcement, then they could put it on their girlfriend's car. If we're not limiting them to the course of their duties or their lawful duties.
John Pierre for the record. I think they would be a private citizen anytime they're off work. I don't think they should get law enforcement protections when they're off duty, unless they're acting in the course and scope of their duties. But I don't want to put that lawful language is
Okay.
a problem.
But you said acting in the course and scope of their duties. So is that okay?
John Pierre for the record, no.
Okay, I'll hand it over to Senator Hansen.
Actually, thank you, Matt. You asked my question. I was just going to say, John, if we took out Section 2, would you be okay with the bill? It is interesting how far down we've been covering so much ground here on what's pretty just, we had two people, a mayor and a county commissioner who had somebody put a tracking device on. And here we are, going back over the Fourth Amendment and Jones versus whatever. Now, my question though, Jones, is that the one that dealt with the Stingray technology issue?
John Pierre for the record, no, it did not, Senator.
Okay.
It dealt with a GPS tracking device applied to a person's automobile.
Okay, so it was specific to this bill, because I got to look it up and read it. But yeah, bottom line is, look, I think we're on the same page. We don't want private citizens doing this. We certainly don't want cops being either granted an exception or, on the other hand, being prosecuted potentially, or evidence being thrown out because they didn't follow this new section of the NRS. I'm curious as to whether or not you would be willing to work with law enforcement and the bill sponsors to come up with an amendment that we can all, I think we're all pretty much on the same page as far as what the intent is. You don't want law enforcement to be able to basically break Fourth Amendment protections. I think are you suggesting the current state of the Nevada law already protects people from, or protects law enforcement, or make sure that they're already, corralled into the relatively narrow window of exceptions that the Fourth Amendment allows?
John Pierre for the record. Senator, I think the issues are kind of twofold and on both sides. And I just want to say, as lawyers do, I disagree with the proponents of the amendment that the original part of this bill is going to somehow put a heightened Fourth Amendment requirement on them to do their duty. Because exigency applies throughout our case law. And I think trying to legislate what exigency is probably not the best idea, because it's really a case-by-case basis that courts need to look at.
But you did say to us when you came up that if you eliminated the law enforcement provision of the bill, you'd be okay with the bill?
Yes, because, John Pierre for the record, only because I think that just leaves us in the current state and prevents the situation that happened to the mayor and other people, which I think is what all of us want to do.
Okay, I think we've gone down this rabbit hole for a while now. So anyway, I thanks, John. I appreciate, as always, your input. Thank you, Madam Chair.
Thank you. Do you mind taking a few more questions?
Fine with that, Chair.
Okay.
Thank you.
Vice Chair Harris.
Thank you, Chair Scheibel. So I think, Mr. Pero, in your testimony, even you're conflating Fourth Amendment law with a new crime, right? And this bill is about when a new crime will apply. And so I think I know what your answer is going to be, but I feel like I got to ask. When an officer violates the Fourth Amendment right, should they be held criminally liable?
John Pierre, for the record, no. Our current state of law doesn't apply that. I don't think that this bill does that. I just don't read it that way. I know that we're all reading it kind of differently, Senator, but I don't read the bill that way. I don't think none of the 17 DAs in Nevada would read the bill that way and charge an officer. Now, should we work on stuff when officers violate rights because Section 1983 is really weak? Yeah, but that's not the concept of this bill. So I'm not trying to go there on this bill, and I don't think this bill goes there.
So I say that because I think your argument is that this bill expands the Fourth Amendment protections, but it doesn't really talk about what's allowed or not allowed under the Fourth Amendment. It just speaks about when someone has committed the crime of unlawful installation. And so I think that is the genesis for the amendment, right? They're trying to ensure that if an officer maybe violates the Fourth Amendment right, whether it be intentionally or unintentionally, that the courts are able to handle it and that an officer doesn't commit the crime that is outlined in this bill.
John Pirro, for the record. Senator, I just don't read the bill as seeing that it creates a crime. And two, I don't read it for officers. And two, I don't read it as expanding Fourth Amendment protections as the proponents of the amendment do. I just read it as keeping everything static.
Okay, so I'm going to follow up on, I think, what the chair was trying to get at, and that is maybe trying to nail down what type of amendment that you would be on board with, because surprisingly enough, the DAs, I think in this moment, have agreed with you more than you probably have agreed all session. And so I think we're this close, right? So if it was clear in this bill somehow that it does not apply to peace officers, whether we end up saying peace officers who are on duty or something to make it clear that when they're not on duty, they are private citizens and still subject to this law, you would be okay with that version of the bill. Is that correct?
John Pirro, for the record. Of course, I would have to see the language, but I still, respectfully, I just disagree with them, and I don't think this bill is going to really affect the way they practice, and those are the disagreements that we've had.
Okay, so
as written.
All right, sorry, Chair, my fault. So one thing that I heard that I thought was a great solution is the Utah law. And it says, so I'm going to give you some language to kind of chew on here. It says, this section does not apply to a peace officer acting in the peace officer's official capacity who installs a tracking device on a motor vehicle in the course of a criminal investigation or pursuant to a court order. Would that accomplish the goals that the proponents are looking for and ameliorate the concerns that you have?
John Pirro, for the record, I would be concerned that it would weaken the U.S. v. Jones case, which says get a warrant.
Okay, one more. And why is that, given that this bill is about committing the crime of unlawful installation and when that happens, not about when a search is allowed or not allowed?
John Pirro, for the record, I think subsection 2 is muddying the waters a little bit. And that's what's putting us in this Fourth Amendment analysis.
Okay, so if we delete 2, you're good.
John Pirro, for the record, yes.
Nailed it. Thank you.
Go ahead, Senator Wynn.
I just want to clarify, and this might be a question for law enforcement. Under current circumstances, if you want to track someone, you can do so under current law if you have a warrant. And can you, under current law, track them under those exigent circumstances that you described in the kidnapping hypothetical? Yes. Is that? I see a lot of head shaking, so I don't know if we can put that actually on the record.
Beth Schmidt for the record, yes. Senator.
Okay. And there is if this only applied to private individuals and we removed Section 2, you would still be able to do what you are currently doing, and we would get around this Fourth Amendment issue that the opposition has currently with this amendment.
Beth Schmidt for the record, yes, and we would support that.
Thank you.
Okay, I'm sorry to put you on the spot, Ms. O'Krent, but question for legal. If we remove Section 2 from the bill, would peace officers still be able to utilize tracking devices without being guilty of this misdemeanor crime?
Carly O'Krent for the record, yes.
All right, I think we should quit while we're ahead. Unless there's any more opposition, and we already took opposition by phone, so we'll now go to testimony in neutral on AB 356. Anybody wishing to testify in neutral is invited up to the front of the room in Carson City or Las Vegas, but I don't see anybody, so we will go to the phones for testimony in neutral.
Thank you, Chair. If you would like to testify in neutral for SB 356, please press star 9 now to take your place in the queue. There are no callers wishing to testify at this time.
All right, then that brings us to the conclusion of testimony. Please come on up and provide us with closing comments, any clarity, and thoughts on removing subsection 2.
Thank you so much, Madam Chair and committee members. I'm just going to forget the closing that I had because I just want to thank you all for this amazing discussion. I mean, I feel like I've just been in a law school class. And but I learned a lot. The reason I asked for exemptions in the initial bill was because I thought we needed to specifically exclude people that we didn't want them to be affected by. But I mean, I'm fine with removing that. If this is a solution for everyone, that's all we want, is for this bill to go through and not harm police officers or anyone it should not be harming. And so thank you again. I also want to thank my co-presenter, Assemblywoman LaRue Hatch, and Serena Evans. They've been so extremely helpful on this, and thank you all again. It's been amazing.
Madam Chair, if I may, just a quick question. Did you guys match on purpose? Because that's adorable.
All right, Assemblymember LaRue Hatch for the record. No, we discovered when we walked in. We matched, but it worked. I guess we got bipartisanship.
I do have red shoes on, though. Hers are black.
There we go. Assemblymember LaRue Hatch for the record. I just want to thank you all for your questions and for digging in and really trying to get to the very best policy. I think through all of that, we have come to an agreement on what our ultimate goal is. And we, as the sponsors, will definitely work with all parties to make sure we're getting what we need so that we can actually protect individuals, because that's what this is about, right? It's protecting privacy, it's protecting victims of stalking and abuse, it's making sure we can't all be spied on. It's also not blowing up the Fourth Amendment and also not criminalizing people for doing their jobs. So we are going to work together to make sure we're addressing that. Thank you.
Thank you both very much. This has been one of our most robust hearings in Senate Judiciary to date, and we really do appreciate it. We appreciate you taking the time to come down here to engage with us, answer all of these questions, and you both did an excellent job. So I will now close the hearing on AB 356 and move to our work session on perhaps the only bills more controversial than this hearing was all session. AB 354 and 355. I know that our schedule has been very unpredictable, so I don't know if the sponsor wanted to be here to answer questions, but I'll go ahead and kick it over to our policy analyst to go through the work session document while I check in on her.
Okay, thanks, Chair. For the record, Patrick Guinan. As the Chair mentioned, we have two bills. Those are Assembly Bills 354 and 355. They're both sponsored by Assemblywoman Howdigi. We heard them in this committee in a joint hearing on April 6th. And just for the committee's note, these are a consent calendar. Neither one has an amendment, so this would be one vote, one motion do pass, and I'll go through the bills individually now quickly. Assembly Bill 354 prohibits, under certain circumstances, a person from possessing or causing a firearm to be present in or within 100 feet of an entrance to a place the person knows or should know is an election site. This prohibition does not apply to a law enforcement officer engaged in the performance of official duties, a private guard or security personnel hired by the owner of the facility or property in which the election site is located, a person who possesses the firearm while in a vehicle so long as the person does not brandish the firearm or remove the firearm from the vehicle, or a person who lawfully possesses a firearm in place in a place of residence, in a business, or on a private property that is located within 100 feet of the entrance to an election site. A person who violates this prohibition is guilty of a gross misdemeanor, except if the person knowingly possesses a firearm or causes a firearm to be present with the specific intent to disrupt, interfere with, or monitor the administration of the election, the counting of votes, or any person who is voting or attempting to vote. Then the person is guilty of a Category D felony. The bill additionally prohibits a person from 1, selling, offering to sell, or transferring, and 2, possessing, purchasing, transporting, or receiving an unfinished frame or receiver, ready frame or receiver, market frame or receiver, unless the recipient is a firearms dealer, importer, or manufacturer, or such a firearm has been imprinted with a serial number issued by a firearms dealer, importer, or manufacturer in accordance with federal law and any adopted regulations. That's the sum of AB 354. Moving now to AB 355. AB 355 provides that a person who is less than 21 years of age is prohibited from handling, having possession of, or controlling any semi-automatic shotgun or semi-automatic centerfire rifle. A person who violates this provision is guilty of a gross misdemeanor. The bill provides an exception for a person who is less than 21 years of age and who is a member or an honorably discharged member of the Armed Forces of the United States, the National Guard, a reserve component, or a law enforcement officer. The bill also provides the following penalties. A person who aids or knowingly permits a person who is less than 21 years of age to handle, possess, or control such firearms is guilty of a misdemeanor for a first offense. A person who knows or has reason to know that there is substantial risk that a person who is less than 21 years of age will use such firearms to commit a violent act is guilty of a Category C felony for a first offense. A person who commits a second or subsequent offense of either crime is guilty of a Category B felony with a prison term of not less than 1 year and not more than 6 years and a fine of not more than $5,000. A person does not violate these provisions if the firearm was stored in a securely locked container or at a secure location, was obtained because of an unlawful entry, or the injury or death resulted from an accident related to a target shooting, sport shooting, or hunting. Additionally, unless a greater penalty is provided by law, a person is guilty of a misdemeanor if the person negligently stores or leaves such firearms at a location under his or her control and knows or has reason to know that a person who is less than 21 years of age, who is prohibited from handling, possessing, or controlling a firearm, may obtain such a firearm. And lastly, the bill clarifies that a child who is 14 years of age or older, who has in his or her possession a valid license to hunt or is at his or her residence, may not handle or control a semi-automatic shotgun or semi-automatic centerfire rifle. And lastly, the bill requires that any rifle or shotgun which a child 14 years of age is otherwise entitled to handle, possess, or control at his or her residence is to remain unloaded and stored in a securely locked container when not in use. That's all, Chair Scheibel.
All right. We don't have the bill sponsor here, but are there any questions on the bill, I guess, for legal or? We'll take a motion first. If there are no questions, I will take a motion to do pass both bills on the consent calendar. I see a motion from Vice Chair Harris and a second from Senator Orenshaw. And now we'll take discussion on the motion, starting with Senator Hansen.
Thank you, Madam Chair. Well, first of all, after that very robust discussion on a single sentence in the Fourth Amendment, unreasonable searches and seizures, I think one of the things that really should have been brought out to all of us is how important it is to be able to hear all sides of an issue. And we heard both of these bills in the joint hearing. We had an hour and 45 minutes of proponents' testimony, and we allowed expert witnesses in the audience a single minute to talk about this bill. Now, this committee is made up of attorneys. Everybody here knows that if you give an hour and 45 minutes to the prosecution and you give a single minute to the defense, what the likelihood is of the jury's decision. And that's what we did in that so-called hearing. Since we're going to actually talk about both bills at the same time, the first bill, Assembly Bill 354, it's already illegal to intimidate in any way, shape, or form anybody attempting to vote in the state of Nevada. That's Section 1 of 354. So that portion is entirely redundant. The portions about now requiring so-called ghost guns to have registration, the entire purpose of that is to allow the ATF to continue to expand what is already illegal, in my opinion, and that is essentially a registry of firearms so that ultimately you could have a potential confiscation by the government. That's the real goal of that. As far as its ability to actually influence crimes, the number of cases where people have actually been prosecuted when they find a weapon that was registered to that individual is almost non-existent. Any criminal with any brains in his head would not use a gun registered to him to commit a crime and then leave it at a crime site. When those things have occurred, in almost every single case, it's because the individual was shot or wounded in the act of the crime, and then the gun could be traced directly to the person committing the crime. On Assembly Bill 355, we have this incredible violation of the Second Amendment for people that are 19, 20 years old. Semi-automatic weapons are the most common weapons used in the United States. These include the AR-15, which has somehow become this big thing where everybody's talking about it. Just so you know, since 2010 in the United States, 200 million firearms have been purchased by private citizens. Estimated 1 out of 5 has been an AR-15. In other words, there's been an expansion of almost 40 million of those weapons since 2010 in the United States. The American people have voted with their pocketbooks that they want to keep semi-automatic weapons, including the AR-15, and they have purchased them. And by the way, I purchased one a couple years ago as well. But what's more fascinating about this bill and disturbing is that it involves semi-automatic shotguns. They are probably one of the most common guns used by hunters, including hunters that are ages 12, 13, 14, 15, including me when I was a young man. Now this will be a criminal act all the way up to 21. Now we just had a great discussion on protecting constitutional rights. Our constitutional right is the Second Amendment right, which clearly says the right of the people to keep and bear arms shall not be infringed. Now, we just talked about very narrow exceptions to the Fourth Amendment, and we want to make sure we protect and keep those exceptionally rare. Yet here we are expanding and absolutely destroying, in some cases, the same Constitution that has been determined by the Supreme Court. The Bill of Rights, the Second Amendment, is now an individual right under our Supreme Court. And here we are, rather than doing everything possible to keep these things as narrow as possible to protect the rights of our citizens, to have those Bill of Rights protections, we are actually now expanding this beyond anything I've ever seen. This whole semi-automatic ban is just not only is it a violation, in my opinion, of the Second Amendment, it violates common sense, and it's going to create a huge criminal class in Nevada out of perfectly reasonable people who are using semi-automatic weapons and all sorts of things, especially hunting. And last but not least, the storage portion of that is really disturbing, because I thought we were getting rid of that. The people that have been buying, in fact, in the last year, there's been this incredible spike of minority women in particular who've been buying handguns because they live in high crime areas and the cops just flat can't get there in time to help prevent crime. And now, if a woman in one of those high crime areas keeps that in a nightstand next to her bed, and somehow the cops show up, she could be prosecuted for not properly storing a firearm and basically denied and criminalizing her ability to protect herself when even the police, by their own acknowledgement, can't get there in a reasonable amount of time. Those people should be, that's exactly an example of where people need the Second Amendment right. So I'm disturbed by this whole process beginning to end. I'm disturbed that we're putting this on a consent calendar. I'm disturbed that the citizens of Nevada were not granted their right to come to a hearing like this and do exactly what Mr. Pirro did and the other public defenders and all the people who obviously helped expand our understanding of where these laws could go. And give an hour and 45 minutes to the prosecution and 1 minute to the defense, it's a very safe bet where the jury's going to go. Now, I realize we are not an impartial jury. Everybody on this panel has probably had their minds made up before the hearings. But what's important is that the citizens of Nevada feel at least they had a right to hear their views and have their views expressed in front of the legal representatives of them to make sure they had a fair hearing and then let the chips fall where they may. But that was deliberately denied to the citizens of this state. And you know, I've been in here, this is my 7th term, 7 times on this committee, and this is probably the one time I really feel almost ashamed of the process. That we, and I will say, Madam Chair, you did your best to make that hearing fair. But in my opinion, that whole process was an embarrassment to the integrity of this body, of this Senate, of the Assembly. That was not a hearing. That was a charade that was masquerading as a hearing. So I am very much opposed to these bills. I think the whole thing was rotten from beginning to end. To put these even on the consent calendar and not have a separate discussion of each bill here in this committee right now when we didn't have a hearing in that thing is like adding salt to the wound. So I'm going to urge my colleagues, both on the constitutional grounds and on fairness grounds and on reasonableness grounds, to vote no on both of these bills today. Thank you, Madam Chair.
Thank you for your remarks. While we disagree on policy, I do agree that having everybody's voices heard does make the process work better. And so I always appreciate your input, Senator Hansen. And Senator Stone.
Thank you, Madam Chair. Before I follow up in my colleagues' comments, I just want to say that I think, Madam Chair, you have been a wonderful chair, and you've always allowed for both sides to be heard. And I know that that wasn't your hearing, and I really believe in my heart if it was your hearing that you would have given deference to the opposition, as you always do. I think you've always been very fair. But I really believe that that hearing in the Assembly was a mockery of democracy. I don't know how else to put it. I think that the opposition needed to be heard. We can always agree to disagree, but everybody deserves equal time before their elected officials to hear both sides of the equation and then come up with their own conclusions and votes. We spent a lot of time today discussing the Fourth Amendment. I almost feel like I'm ready to take the Nevada State Bar. I learned so much today. I could be a justice of the peace, maybe. Who knows? A new career, like I need another career. But we're talking about the integrity of the United States Constitution. And what is probably most disturbing to me about AB 355 is that you had a mirror image of the exact same law that was passed by the California legislature. And the Ninth Court of Appeals, Federal Court of Appeals, has ruled that California's ban on the rule of semi-automatic weapons to, the sale of semi-automatic weapons to adults, young adults under 21, to be unconstitutional. And Judge Ryan Nelson even opined and said, the Constitution still protects the rights of young adults to keep and bear arms. And the last thing we want to do is we want to keep some of our young hunters from being arrested by police for their hunting hobbies. And we have a lot of hunters, and certainly in northern Nevada, maybe not as much in southern Nevada, although we think we have it there too. And this has been a cultural sport here in Nevada that families pass on from one generation to another, and now we're criminalizing those efforts. My concern about AB, I also agree with my colleague about we have a lot of single moms that want to protect their families and their apartments and their condos and their homes. And the response time of public safety officers isn't always as fast as we would like, and sometimes a minute or two can make the difference between somebody fending off a criminal that's trying to break through a window to attack a family. And sometimes that weapon needs to be readily accessed. They can't go into a safe and get it while somebody's taking a crowbar to their window. They need to have it by close by, whether it's under their mattress, hopefully where their kids don't know where it is, but be able to protect themselves and their family, and that's what I think the Second Amendment's all about. It's the right to bear arms, to protect yourself, and I think we're taking those rights away from a lot of single moms. With respect to AB 354, if this gets passed, it's obviously going to be well publicized that all areas where we vote are going to be gun-free zones. And while we think that that's safe, I think that it's going to invite some nefarious people that know that there's no one there to defend themselves. When we go to the polls, it could be a contentious election, and I worry that there are going to be potential mayhem if we don't have people that can constitutionally carry with CCWs and at least have some type of a defense in case a crazy person goes and unloads their weapons. So for those reasons, I would urge the committee to vote no on these bills on the consent calendar today.
All right. Any other comments or discussion on the motion? All right, there is a motion on the table to do pass both of these bills on the consent calendar. All those in favor, aye. Aye. Any opposed, nay? All right, the nays are Senators Krasner, Stone, and Hansen. The rest are ayes. The motions pass. And I will assign the floor statements. Is there a volunteer for AB 354? That will go to Vice Chair Harris. Is there a volunteer for AB 355? That will go to Senator Orenshaw. All right, I believe that concludes, oh no, public comment. That does not conclude our business for the day. We will now go to public comment. Anybody wishing to give public comment in person is invited up to the front of the room to do so now, but I don't see anybody coming up to the front, so we will go to the phones for public comment, 2 minutes per person.
Thank you, Chair. The public lines are open and working. However, there are no callers wishing to offer public comment at this time.
All right, then that brings us to the conclusion of our meeting for today. I'm going to ask the members and staff to hang back just for a second so we can take our committee picture and memorialize this wonderful time that we've had in Judiciary. And we will be meeting again on Monday. I think we've published most of the agendas for next week, but not all of them because I have not gotten back to my committee manager about all the bills that I'm hearing, but do expect that we'll be meeting at 1 o'clock every day next week. And until Monday, we are adjourned.